So today I am pleased to welcome to the studio Barry Vitou, a partner at Pinsent Masons and head of their global corporate crime team. So Barry, rather than recite your profile, your public profile, can you tell us a little bit about how you got to be the head of the global corporate crime team at Pinsent Masons? And welcome to the studio.
Well, thank you very much for inviting me in. That is a very long story, but I suppose it all starts, my interest in this space all starts in Russia. So that's where I cut my teeth.
Interesting.
Yeah.
In what way?
Obviously Russia is a challenging place to do business. Sure. So looking at allegations of these sorts of allegations that we would be looking at around corruption, money laundering, that sort of stuff.
So that sort of got your interest in this particular field?
Well, it was a forced interest.
As career decisions are sometimes.
Yeah, exactly. So what gets me into Pinsent Masons, which was your question. So in 2010, I guess, the Bribery Act hoved into view. Right. I looked at the sort of experiences that I'd had over the preceding years, and I just thought, well, this is obviously going to be an interesting area of legal practice. Pinsent Masons were interested in developing that for their client base, and so I went in to set it up with another colleague from scratch starting in February 2011.
Wow. So let's talk about the Serious Fraud Office for a moment and the National Crime Agency, the NCA. So taking a bit of a snapshot for those who might not be familiar with some of the current issues, how are those two organized from an investigatory and prosecutorial standpoint, and what exactly is the role and mandate of each?
Okay, well, the Serious Fraud Office is very straightforward. That is to investigate and prosecute serious crime, serious fraud. The NCA has a much broader remit. Both agencies sit under the responsibility of different government ministries, I suppose. Well, the SFO sits in the Attorney General's office. The NCA sits in the Home Office, which is our now Prime Minister, who was formerly the Home Secretary. That was her department. The remit of the NCA is extraordinarily broad. It does include within it an anti-bribery or a bribery sort of money laundering function. But I think it would be fair to say that it is not focused exclusively on the serious side of it. I suppose if I was to draw, they would probably disagree with my segmentation of them, but they've certainly spent a lot of time looking at perhaps bribe receivers, so PEPs, politically exposed persons, that sort of thing. And I think historically at least less time spent investigating perhaps bribe payers and corporates. So the SFL, on the other hand, is well known what they get up to. You can read about it more or less every week, if not every day, in mainstream media all over the place.
So the Bribery Act, I understand, covers commercial bribery as well, not just the FCPA mandate, which is transactions involving public officials. So what's the difference between the two laws in terms of what sort of transactions and behavior they cover?
Yeah, I mean, I think it depends on how if you want to take a sort of a very detailed sort of unpick them both, they're obviously very different, they use different words, but in terms of big picture, I think they're extremely similar. I think in terms of what is ultimately investigated and prosecuted, they are quite similar. As you say, there is a distinction between public and private bribery. The FCPA does not cover private bribery. The Bribery Act covers private bribery, as the UK's anti-corruption laws have always catered for that in some way. And so there are outlier cases I know in the US where they've used Travel Act and other guises to investigate and prosecute private bribery. But yeah, that would be the biggest distinction. But in many ways, they're very similar.
And what about international law enforcement cooperation with the SFO? So as someone who was nearly carbon copy prosecuted and entered into a non-prosecution agreement with the Crown Prosecution Service, you know, sitting in a room and being monitored by the City of London Police and the FBI, I saw the real teeth of international law enforcement cooperation. Now, Barry, that was back in 2009. What's the status of that today?
Well, I think the cooperation remains very strong. I think it's assisted by the relationship over the years that the UK and the US have definitely had. It's helped because, subject to two nations divided by a common language, we're both speaking a sort of English, so people can more readily understand each other than perhaps they could if they were dealing with another language.
Sure.
There are many similarities. Today, I think you will probably find secondees from both organisations in each working in each other's offices. You'll probably find that there are routine sort of catch-ups in terms of cases that they have. There will be, I mean, just because of the nature of, you've got two very large financial centres, that drives collaboration and communication. So you will find that there will be cases in the US which will be of interest to UK and vice versa. So there are various statistics which are put out from time to time about enforcement of these sorts of issues. And I know that the US is always up there as number one as the world's global cop. But the UK, much maligned for inaction in relation to these things, but frequently is in the top 5 as well.
Right, sure.
And so you would expect the world's global cop, aka the US, to be in close dialogue with those that are in sort of the pack following behind, but the relatively small pack following behind.
So it sounds like there's a very robust formal and informal network of cooperation.
I think that's right, and it's certainly the case. It doesn't end there for the SFO. They have other arrangements with other law enforcement agencies, and they're not necessarily the ones that you think. But for example, I was recently in Singapore. The SFO were out there. They have a contact operating out of the consulate there from HMRC of all things, and he was quarterbacking the SFO anti-corruption week they were running in Singapore, and so I think you should assume that there is pretty strong coordination amongst international law enforcement agencies like the UK, the US, and other developed nations, and in some not so developed nations.
Right. Understood. So let's get controversial for a minute. Okay.
Unlike me.
So you mentioned in an interview that the SFO, I believe it was David Green, has noted his discomfort with DPA incentives under the present UK regime. So is there talk of change? And I know you spoke about this in a recent Wall Street Journal piece. What do you think about the current program? And this is a huge issue, it seems, of discussion on both sides of the Atlantic.
Okay, well, the issue in the UK is that the discount that you can receive by self-reporting and through a deferred prosecution agreement is now at a maximum of 50%. The sentencing guidelines permit a third off, but in the recent XYZ DPA, they gave a 50% discount. For simply pleading guilty at the first available opportunity, you would get a third off under the rules. So your incremental benefit on self-reporting to get a DPA would be, and walking in and saying you did it, would be 17%.
To self-disclose.
To self-disclose. But on top of that, of course, you can add the fact that you have turned a contingent liability into an actual liability, because if you say that, you are going to be paying something. So there is a number going onto your P&L and a contingent liability in your balance sheet pending that. You will also have the cost of investigation, which we all know is significant, 7 digits minimum, but often multiples of that, and eye-watering multiples of that as well. So when you sort of add in the costs of that, it seems to me that the economic calculus is at best the same, if not worse, which is a difficult thing to sell, it seems to me, in terms of incentivizing people to go in. On top of that, of course, you have to add in that in the context of a self-reporting company, the chances are that they are going to end up with some form of monitorship,
Sure.
even if it's not called that, and probably ongoing cooperation. Whereas the company that doesn't go in waits to see if it is uncovered, and then perhaps doesn't even cooperate as part of that investigation, provided that they're not involved in an ongoing scheme of criminality, which would obviously be a different thing. But if we're talking about historic matters, it might find itself in a situation of getting a third off, not having played sort of the game at all. And I think
You mean getting caught and then pleading guilty?
well,
getting a third
well,
off?
I mean that a company that if you go in, you are cooperating from day one. You're saying you did it. You're telling them something that they did not know, and you trigger those costs and get your 50% off, but you've got your cost investigation. A company that is uncovered involved in some sort of historic, and I emphasise that, criminal conduct, then it basically is involved in an adversarial, to a degree, process with its investigators, who ultimately, let's say, decide after a 2-year period that that they are decided they're going to charge. At that point, if at the point that they decide to charge, that company then says, you know what, we did it.
Right.
After all of that reluctant bride being dragged to the sort of well, not drinking, then plead guilty, they will still get a third off.
Without the investigatory costs.
Well,
potentially.
yeah, without the investigatory costs, because of course if you're not cooperating, they may take the view they don't want to investigate it either, right? They're just going to comply with whatever demands are made to compel information from them. Now, that is an extreme position. Any good defence lawyer will tell you that they at least want to have sight of what it is you're forking over to the prosecutor, so they understand that. But that is a far cry from some of the sort of boil the ocean type tactics that have been engaged in relation to some of the self-reporting cases where the cost of investigation have been in not the tens, or they've been in the hundreds of millions of dollars category. And so it seems to me that if there is a public policy imperative, and it seems to me that there is a public policy imperative, of wanting corporates to self-disclose, which must be right, it seems to me, for all sorts of reasons, namely a reduction on the public purse, the burden, and generally it's a good thing to stamp out corruption, which distorts markets, then the incentive for companies to do the right thing must be there, and it must be marked. And I don't think that a theoretical 17% discount with, on top of that, to add investigatory costs, ongoing cooperation and a monitor versus a fine and walk away after playing to see whether they ever get found out in the first place, is that contrast.
Well, David Green recently said the SFO is still on a learning curve with respect to DPAs. Are they revisiting this issue?
Well, I think XYZ is a great example of having been revisited. It started off that the maximum discount you could get in both cases was a third, and the SFO, if you look back 12 months ago at what they were saying, they said the big distinction between the big benefit for a company in self-reporting was that they did not get a conviction.
Right.
And I think that is an important distinction in circumstances where a conviction and the nature of that conviction would have a very damaging impact on your business. But in circumstances where, depending on the nature of the offence, that's not the case, so Section 7 does not have mandatory debarment, for example.
Okay. That's the failure to prevent.
The failure to prevent offence, then the same can't be said to be true. And if you chart right back to when the Bribery Act was being discussed, it having been passed but not yet implemented, the government of the time, against a backdrop where there was significant disquiet from the business community about the prospect that the bar was being placed very low for prosecution, and a concern that that could criminalise a lot of companies, were informed by the then, I think, Minister of Justice Ken Clarke and Anti-Corruption Czar, that Section 7 would not carry with it mandatory debarment. If you recall, at that time, there were no DPAs. Right. There was no emergency escape route for companies that got convicted. That all followed later. So
It was plead guilty or go to trial.
right. So the whole of the Bribery Act was set up with a legal background that companies did not have the ability to do a DPA. They faced the prospect of being convicted for that. And so, it was never against a backdrop where there was significant disquiet that conviction could end businesses, and Section 7 was designed to make sure that would not happen.
And has Section 7, that pertains just to corporations, not to individuals, correct? And what's the sort of executive summary of what Section 7 is? How does it get deployed?
Well, it's a failure to. It is the clue is in the name. It is a failure to prevent bribery. Corporations. The criminal law, the criminal justice system, is not a great way of punishing corporations, because the ultimate sanction for committing a criminal offence is that you get sent to prison. Well, that you cannot do with a corporation.
Right.
So, in some ways, the whole of the criminal justice system is sort of square peg round hole when it comes to corporations. Right. A corporation is just a book of papers at the end of the day. It only acts through the agency of humans, right? That's the only way that it can do anything. So there's always going to be a human wrongdoer. Even if that human wrongdoer programs some AI to make the company do the wrong thing, there's going to be a human at the end of it somewhere, as it stands at the moment. So against that backdrop, Section 7 is all about, if one of your third parties, but typically an employee or an agent or a distributor, does something that benefits the company, which is a bribe, then the company is guilty of failure to prevent bribery unless it can prove that it has put in place adequate procedures to prevent that. That does not mean that they are perfect procedures and that the moment that there is a bribe they've failed and therefore you are guilty. It just means adequate procedures. But so that's how it works.
So in the U.S., the DOJ recently brought on a compliance council to help analyze those sort of compliance programs and procedures to see if they're really robust, if they were designed to, prevent the conduct. How does the UK analyze that sort of behavior on a corporate perspective?
Yeah, I think that I would say that they are somewhat behind the US in that degree of sophistication, albeit that the appointment of that, I think the lady's a consultant from recollection, is only a late-breaking development. It's only been within the last couple of years that that's happened, isn't it? In the UK, that is not the case. They will, I think, quite vigorously look at a corporate compliance program to understand whether a good faith attempt has been made. The people that you are dealing with in UK law enforcement, by and large, do not come from a commercial background, and they do not necessarily understand the sort of relativity, shall we say, that has to be factored into these compliance programs, nor, I think, the complexity of operating global businesses. There is perhaps an assumption that something which, on the face of it, you might say, it should be very simple to get, documents from 20 jurisdictions by the end of next week, for example, in circumstances where we both know that that something which appears that simple could take months to pull together for all sorts of very good reasons. So I think there is that piece missing, but there is a defence, and I would hope we haven't. I don't think we've seen one yet, and I don't think we've seen that many in the US, where companies with what we would say are adequate procedures are then unfairly sort of pursued by law enforcement. I think based on those UK examples we've seen to date, and also the sort of statement of facts that you read about in the US examples, typically there are sort of fairly significant failings which are a precursor to some sort of problem and then enforcement action.
Well, one final question, and I failed in my introduction of you to mention that you are the editor-in-chief and publisher of the Bribery Act, www.thebriberyact.com, which is a wonderful blog. So my first question is, how did you get that domain before the regulators did? And tell us a little bit about your blog.
Okay, well, how I got the domain is fairly simple. In the summer of 2010, I was poolside reading my paper Kindle, the old-fashioned version, and I was reading the FCPA blog, catching up. This is how interesting I am on my holidays. And I suddenly had an epiphany where I realised I'm quite into tech, that this was crazy. I should have my own blog for the Bribery Act, and I should call it thebriberyact.com. So I went racing back to my hotel room where I had my laptop, because I'm sad on holiday, and I logged on to, I can't remember the name of them now, but the web domain outfit, and punched in thebriberyact.com, and to my surprise, they were all there. So I basically bought them all. It took a little while because the wireless connection was so poor in my hotel room, but I did buy all those domains. So that's how I got it. And the blog covers all things Bribery Act and related. So it will deal with DPAs, it deals with money laundering, proceeds of crime type issues in the UK. It's a pretty discreet website. I write it, so it's basically a case of what interests me, but I do cover what I consider to be all of the important developments in the as the law and the practice around the Bribery Act evolve.
Well, terrific. It's a wonderful blog. And Barry, thank you for joining us today.
Thank you.
Appreciate it. My pleasure.